We want to welcome everyone here, and we thank Sally for joining us today. We're really looking forward to the presentation. Again, we want to do a little plug for our social media. Please follow us on LinkedIn, Facebook, and the bottom link is the community webpage on the Chicago Association Management website. A little bit of housekeeping. We do want everyone to stay muted unless you're, need to unmute and ask a question. You can use the chat to place questions for Sally in the chat or to introduce yourself. Would love for you to reach out, say where you're from, that you're joining us today. And we will go ahead and drop any important links in the chat that are mentioned during the presentation. And for technical help, you can contact Caitlin, who is on with me, or you can call 312-540-9300 and we will help you out. So I'm going to turn it over to Ed to introduce Sally.
Great. Thank you, Shelby, and thank you to my team who helped put this together. And of course, thank you to everyone who's participating in this session. We will record it, of course, and so you can have access to be able to share with your other board members and all that kind of good stuff. So Sally, I met Sally through David Schreier, and we had a conversation, maybe it was 2 months ago, maybe a month and a half ago. And the energy level that Sally had and the stories that she had and the obvious knowledge base was simply awesome. And so I think you're really going to enjoy this presentation. It's going to be a good resource for you with your boards if you do run into any of these type of issues or some of the things that she brings up. And of course, she's a good resource there. I also noted in our pre-event call here that Sally is an oboist for a degree at the University of Mississippi, I believe. And we decided that anyone who's willing to take on an oboe as an instrument is probably going to be a very good attorney. And Sally said that a lot of oboists turn into attorneys. So with that one piece of side information, I will turn it over.
Well, thank you very much, Ed. And it's really a pleasure to be here, Shelby and Caitlin, for your help in making this easy. And for David and teeing all this up. David told you all the good things to do and how to lead well, govern well. And I'm here to tell you all the bad things that can happen and the problems that can arise. I think people come to my office in two ways. They come either to plan or they come in crisis. And most people know which kind of door they want to enter through. So it's better to do things well proactively than to have to react to have problems. But life is full of problems. Life is full of challenges, and many of them are good and can be used for wonderful advantage. And I appreciate the little music side note too. I think it's good for people to be involved in all sorts of things in addition to their day job, so to speak. And I think that's where trade associations are interesting, because this can be an adjunct to what you do otherwise, or can really be in furtherance of the work that you do. I actually counsel a lot of 501c3 organizations as well as trade association 501c6s. And so I think many of you may be involved with C3s as well. And a lot of the information that I'm going to share would really apply to both, because they're both not-for-profit organizations and they're both tax-exempt organizations, just under different subsections with some important implications because of that. But I think we've got a lot of common ground here. So I will go ahead and share my screen, and someone will tell me if I didn't do this right, because we practiced. That's the other thing I learned from music, right? Is we practice. All right, all good? Okay, so a little bit of more introduction about our law firm. We work mostly with not-for-profits. We have a Chicago office as well as a Charleston office. They're getting ready to get out in the midst of hurricane, tropical rain weather right now. So it's nice to have a beautiful day in Chicago. I do really appreciate the opportunity to speak with you all, being in the trenches of nonprofit work as leaders, and to build on David Schreier's excellent presentation last week. I really love the description for this two-part workshop, that good governance is closely related to the success of nonprofit organizations, from how impactful their programs are to their financial health, to how engaged their leaders are. So to effectively govern, boards must act responsibly and effectively. And that's why you're here to continue that dialogue, that conversation. David focused on best practices in nonprofit governance related to stakeholder accountability, mission, planning, finances, fundraising, performance, and communications. Wow. So I'm going to build on that information, particularly from a legal perspective, to dig into applicable legal standards, to provide real world examples, to walk through key governance materials, and hopefully to provide you all with some encouragement too. And our session today will allow for question and answer along the way. So please feel free to add to the chat with any questions you have. I'll try to take a look at those here and there. We're going to pause a little bit along the way. This is a lengthy webinar, and so strap in, get your lunch or your coffee or whatever. I'm going to share information, and then I will pause at various times to see who would like to raise a hand and ask a question, or otherwise as we dialogue through the chat. All right, so let's see. Moving right along here. Okay, so just a little bit of overview. Here's the big picture. We're going to talk about governance, as we've said kind of in and throughout, but with some preliminary concepts. We'll talk about fiduciary responsibilities. David touched on those before. I'm going to expand on them. Potential personal liability. Don't want to forget as well organizational liability. A lot of leaders say, well, could I be held liable? But within that, there's things about how you lead this organization, both for its own protection as well as your own personal protection. And then we'll dive in a little bit to bylaws, particularly with respect to the membership dynamics of trade associations, corporate governance, and then of course, advancing the mission, which is where we kind of wrap it all up together. And so one thing that I like to do when I counsel organizations is to ask them, well, why are you here? I've given a version of this presentation to many other boards and other professional contexts. And I thought it was quite transformational once when I came armed with my PowerPoint for this board. And the reason why I was asked by the executive director, and it's a little bit of a lonely profit hard position to be in, because the executive director said, look, we've got a phenomenal board. We probably have 15 or so board members, a significantly large board. They're leaders in academics, they're leaders in business, they're leaders in other ways, but they don't fundraise for us. They don't bring in the money, and it's really frustrating. So can you come and kind of beat them up? And I said, well, I don't beat people up. I might coach people up. So I want to ask them, talk to them about their fiduciary responsibilities. So we'll talk about that more as well. Care, loyalty, and obedience. We'll talk about accountability to the government, IRS, to others, to your donors, to your members, those kinds of things. But when I got to this board meeting, I kind of pushed aside my PowerPoint for probably about a third of the time. And I just asked them, why are you here? And it was tremendously diagnostic. And what some of it, they had various answers, but they generally fell into the following categories. One was, I like the organization, I want to help them, and that's great. Or, you know, I've got these this academic connection. I'm at a college, and you know, there's a lot of overlap. They do research. Somebody else said, well, I'm a leader in this industry, and so I'm really interested in what kind of projects they do. And all of them had some good reason, to network, to get to know other people. There's nothing wrong with that. They all had some really good reasons, but nothing that necessarily jived with the mission. And so we explored that a little bit more. When I say jive with the mission, I mean, they didn't come in to say, well, I can't wait. When I get up in the morning, I can't wait to fundraise, or I can't wait to micromanage, which David talked about how that's bad. And so they were a little bit in the woods, or a little bit cloudy about what all that meant. And one of them actually said, I think I need to resign today because I have a conflict of interest, because I go get grants for my university and I'm supposed to be fundraising here. I mean, I feel kind of getting beat up about that. So I think I just better resign. And I thought, oh no, like that's the last thing I want, is to come in to speak and have people start resigning. So we talked about that. And what really bubbled up and came out of that was this coalesced understanding, just like David spoke about, that every single board member, every single leader is an ambassador for the organization. You're out there to say, look how wonderful we are. Here's our mission. You should know it cold. Here's what is exciting about our mission. Here's why somebody should donate. Here's why some members should join. Here's why we should all be excited about this. And to the extent that people have these other connections, potential grant opportunities, other ways that people are networked and leveraged, we can deal with that, and we will and we need to talk about conflicts of interest and how they might arise. But fundamentally, I think that's a tremendous advantage. And that's why people are on boards, because they have those connections, because they have those interests and those overlapping dynamics. So we ended that board meeting with people really energized and excited about being an ambassador for the organization, and with a clarified understanding of how these things play out. And nobody resigned, I'm glad to say, and hopefully they raised lots of money, and the executive director was very happy with that. And so that was very transformational. So we won't go into that unless, as you have questions along the way, if you want to chip in and share, why you are here when we pause, you're welcome to do that. But I want you to think about it in terms of fiduciary duties as well as develop your accountability, and with some cautions about personal liability. Okay, so let's set the stage here. So what does it mean to be in a governance responsibility? There's some different roles here. Fundamentally, you have directors. Sometimes they're called trustees. They could be called under other leaders. They're often volunteers, maybe not so much in a trade association, or not, depends. But if you're a volunteer, and I'll talk about this a little bit later, there's going to be a Good Samaritan standard, which means that you're not going to be liable unless there's gross negligence or intentional misconduct. So that's one of the things, just to put a pin in that, that I encourage folks, to the extent that people may want to pay directors a stipend, an honorarium, or something like that, $1,000 a year, or something that's just really meant to value their time, which is a great idea. The problem with that is once directors get paid, they're held to a lower standard for liability under ordinary negligence versus gross negligence. So typically it's better if directors are volunteers. They are entrusted with governing the organization on a day-to-day basis. The board, excuse me, not on a day-to-day basis, but from an oversight perspective, management, however you structure your management, those are who are running the organizations. Directors are in there to exercise oversight, and the bylaws address what it means to be a director, how they get on, how they get off. Somebody just emailed me the other day, and it was such a sweet email, but I thought, oh, you're totally wrong. But he said he was diagnosed with a life-threatening condition. He thought he was about to die, and thankfully he is on the mend. He's got medicine, but it caused him to think, well, what do I do with my nonprofit? So he said, how do I name my beneficiary? I thought, what a sweet question, but totally wrong, because nonprofits are controlled. They are not owned. It is not like a trust that you set up and then you identify who your trustee and your beneficiary is and all that. So we will talk about bylaws, and I think you probably intuitively know that, but it was really surprising to me. I've been doing nonprofit law since 2005, and I continue to get new questions, and I've had a variation of that question, but never so clearly as to, who would be my beneficiary. Sometimes when people set up their organizations, they think like they want to do that. They want to have the heir apparent. They want to have the total control over who all the directors are going to be, and that's typically not possible because of the nature of nonprofits. So that was an interesting question. And then we've got some bumper guards of the Illinois Not-for-Profit Act. For example, the Illinois Not-for-Profit Act says you have to have at least 3 directors. You need to have a range of 5, which means you can have 3 to 8, 4 to 9, you can have 10 to 15. It's kind of interesting. And really, as a best practice, it's a good idea to prescribe a range, like 4 to 9 directors. That's a sweet spot of a relatively robust organization that's not too big. And so the Not-for-Profit Act has lots of nice provisions in it. And directors, as an attorney, I really like to emphasize that words have power. Words are very important. And so we want to be particular with our speech. And so you may say members of the board, which is generally fine, but it's important to distinguish between directors who govern and members who would participate, like in a club. And sometimes members have certain rights, like to elect or remove the directors or to vote on other matters. But you just want to be careful in your nomenclature, especially in the bylaws, because then you have all these different issues about what does it mean to be a member, what does it mean to be a director, and let's be very precise with our speech. And so speaking of that, we also want to think about officers. Officers are typically folks with special roles. I have children, they're now grown, but I've often said, when they were in preschool, we had the whoever, who gets to turn out the lights, who gets to feed the fish. So not to be pejorative or diminutive here, but officers have special roles like that. And so they're the president or the chair secretary, treasurer. This is all very familiar to you. You don't have to name them anything in specifically, but as some of you may know from filing your annual report, the annual report with the Secretary of State will say who's your president, who's your secretary. And so generally speaking, it's good to use titles that others are going to understand and you don't have to worry so much. I do a lot of work with religious organizations. And so you have a pastor or imam or a priest. Sometimes those people are the president. So for legal purposes, the bylaws would say, for legal purposes, the head, whatever, is known as the president. So you can fill in the blanks on whatever government forms you have to complete. And then you could have some key employees in the bylaws. And typically that would be maybe somebody who is the executive director who also serves as the president, or an executive director who's not the president. And so you want to think about such things, how you identify them in the bylaws. And again, I'll go into that in more detail, but also what role they have in terms of potential responsibility and potential liability. And so really to sum that up, all three categories here, directors, officers, and key employees, are fiduciaries. So what does that mean here? Well, fiduciary most fundamentally means entrusted with. Fiduciary on the screen here, it's the person to whom property or power is entrusted for the benefit of another. So it's really a trusted person. And so we want to take that very seriously. I remember years ago, there was a Chicago Tribune headline that said, how could some affordable housing, I think it was the president and director of the board, some president was getting $600,000 a year as annual salary, and maybe they're the best thing ever, maybe not, but it seemed rather sketchy. The Tribune was very critical. This was somebody that didn't do a lot of work but was getting paid arm and a leg to help the poorest of the poor. And they had a few quotes from other people on the board. One of the board members said, "I didn't even know I was on the board." When did that happen? Another person, I don't know why they talked to the press, that's another story. Another person said, "Well, I was on the board, but I didn't vote on those kinds of things." Like, are you kidding? If you're on the board, you are a fiduciary. You're entrusted with things like figuring out the executive compensation. And so they were really on the hot seat. I don't know whatever happened to them all. So I want to talk a little bit about this hourglass. This is one of my favorite analogies. And I think David addressed this a little bit differently, but it's the same idea. He had a kind of above the line and below the line. So if you want to look at the pinch point and think of it in the same idea. So conceptually, the board is at the top. That doesn't necessarily mean they're most important, but they are quite critical. So the board's, another analogy here is they serve as the bumper guards, making sure that the organization stays true to the mission, is legally compliant, and serves its constituencies. So there's the board at the top. The pinch point is the executive director or the executive function. It could be a cadre of people. And then at the bottom, but by no means the least important, are the minions, are the workers. And so when you have a very well-developed organization, say with a strong board of 10, an executive director, and then you've got a staff of, 20 or 30, it's easy to understand this. The executive director is responsive to the board upwards, as well as carrying out or executing the plan that the board has approved downward to the staff. And so the board may have developed a strategic plan or may have accepted the strategic plan or tweaked it however the executive staff presented it. But fundamentally, the board is passing on, overseeing what the executive director is doing, and therefore the executive director is accountable to the board for carrying out the plans with all the workers. So sometimes some of these things get kind of strange in application. If you think about a small organization where maybe the executive director, oftentimes the founder, is also on the board, is also taking out the trash and making sure that everybody gets their cocktails at the event. Sometimes the volunteers are the board. And so when you have something more like a working board, that's a common phrase I hear, then you have to think more, not that you throw out the hourglass, but you think about those functions and how important they are. And one little war story I have is quite personal to me. I was on the board, large organization, came up with a friend of mine who had this wonderful idea. And so we pitched it to the full board at the top of that hourglass. The executive director was really irritated with me because I was taking up board space talking about a plan that had not come through him. And I couldn't imagine why he would be so angry with me, since obviously it was a good idea and I'm on the board, so I have a lot of power. So there. So we went to the board meeting, we got soundly whacked because what we were doing is we were really at the bottom of that hourglass. Even though we were board members, our idea was for a new program that didn't fit with the mission of the organization. And as David talked about, and I'll talk about, you board members have a duty of obedience to the mission. They can change the mission, they can modify it, but I was really violating being on both ends of that hourglass. And the board came back and said, that's a great idea, but it doesn't fit with our mission, and we're not going to change our mission, so we reject your idea. Sorry. And I was really irritated. And then, but I learned a lot from it, and so that's why I share it. And one of the things I learned besides board governance is sometimes other people run with an idea. So sure enough, another organization was birthed. It's still going. It's a phenomenal organization. They do amazing things. The organization that I was on the board for, we do a little collaboration, but that's how that hourglass really taught me to make sure, that we do things basically decent and proper order, because when we blur those lines, that's where some trouble comes up. I was irritated. Thankfully, we worked through that. The executive director was irritated. Maybe we all irritated. We go our separate ways and we're mad, and I'll never donate to that organization. Or maybe we work it through and we're all better for it, stronger for it. Okay, so some concepts here. I just want to run through a couple slides here. These are slides I use quite often in terms of how to think about being on the board, and this really overlaps with what David talked about. So when you think about a board, it's important for them to be independent at that top of that hourglass. In my example, I think people liked me, I liked them, but they didn't put their interests of friendship above their job to act as independent advisors. And that's especially important when it comes to compensation, but also other matters too. And David talked about oversight versus management, not figuring out, picking out the fabric color and whatnot. And so this is very tricky in application. It's one of those, you know it when you see it, but sometimes not. So here's some overarching principles about not managing. Well, what's not managing? It kind of depends. But when you tread over into that area, it's good to kind of check that, and having good structure, that the board is overall independent. Sometimes you may have these episodic conflicts, which is really what I shared with you. You could have dysfunctional governance. I think David talked about the founder's syndrome. I'll talk about it a little bit more too. Dysfunctional governance in my example would have been, well, hey, Sally, since we like you and we don't want to irritate you, you're a lawyer, you know this stuff, we'll just go with what you want to do. Well, it wasn't a good idea, because if we had continued with that program, especially without changing the mission, we would have had confusion among our donors and our stakeholders. We would have been operating really in violation of our mission statement, and it would have been a bad thing. And I think it would have really, maybe the executive director could have gotten excited about it, maybe not. And so it was a good thing that he was not on the board. He wasn't really working in that within that structure, but he was really being responsive to the board and helpful. So these are just, again, good things to think about. And when you have questions and issues, it's helpful to think about what else is going on, perhaps what other problems there are, and how can we step back and really allow the genius of the nonprofit board structure to operate optimally. So what exactly does oversight look like? Here's a couple quotes from lawyerly type resources. It's a collegial relationship that's supportive as well as watchful, challenging yet positive. I think David talked about positive conflict. And so we want to have a robust dialogue, arm's length, but not adversary. So those are just some good things. And I think that is a good reason why you have dinners together or other social activities. You want to be friendly, not to take advantage of each other and leverage that in a negative way, but to say, look, let's build a culture of trust and support, so that when we ask those hard questions, they don't come in as zingers and as attacks, but instead iron sharpening iron to help each other to get to good places within that healthy structure. Similarly, there's a quote that I use quite a lot from Michael Peregrine. I think he's a Chicago attorney, and this came from the ABA, I believe. But it's the best practices call for rejecting a culture of passivity. This was in the context, the quote is of a senior executive. Instead of adopting a new culture, stressing constructive skepticism in pursuit of oversight, not a climate of confrontation, but rather directors playing a more active, independent role. One example that I have of this, a lot of times I tell my clients, it's really good to be boring. Boring not in program, boring not in vision, but boring in legal compliance, boring in the way you do things with excellence. And I served on a board years ago. It was a wonderful board, and we had boring meetings because we had a very, very high functioning executive team, including the executive director, who would say, here's all the reports. I think David talked about, write some things up and submit it in your meeting, and then get to the heart of what you want to talk about. So we had that kind of a culture where we had lots of reports. We didn't go through them ad nauseum. We got right to the heart of things. And it was boring in the sense of like, here's, 5 pages of financials, and then we could ask about 3 lines, because that's all we needed to do. We had constructive skepticism about a few things because it was just such a high level of excellence. So it was a joy to be on that board. A little sadly, that executive director was served for many years, which is wonderful. But then when he left, since then they've gone through a lot of problems because the board had gotten a little sleepy. It was a little too boring, and they just relied on him so much that they didn't really know how to function. And I went to one of their board meetings about a year ago, and it was very, very uncomfortable. They had a lot of high functioning staff who had kind of nature abhors the vacuum. So the staff was running with the show. One of the most peaceful people I've ever met, who I've known for a long time, were kind, hardly ever raised her voice to anything. She spoke up and said, are we supposed to be voting on this thing? It was about like purchasing a major purchase of real estate. Are we supposed to? Are we allowed to? And that showed me that they had gotten into a culture of passivity because they'd just gotten too boring. So even if you have the best executive director ever, the board, or even if you are the best executive director ever, welcome those opportunities from the board so that people don't get sleepy or lazy and end up with problems. And the new executive director is having quite a hard time really getting them back to a healthy place. Okay, so let's talk a little bit about liability here, and remembering too that there's potential organizational liability. So I'm going to start at the bottom because that's something that I have maybe not emphasized as much as I should. And it's really important and helpful to know that because you're operating an organization, we live in a litigious world, whether somebody slips in an event, or there's an employment problem, or there's just a plethora of potential problems that people can run into. I think recently somebody called me and said, we lent somebody a vehicle just for one time and they had a car accident on the way home from work. Are we liable? There's just so many times where there could be potential liability, which is why you have insurance, which is great. And so you really want to fulfill your responsibilities so that the organization is protected from liability. But oftentimes people want to know, well, what about me? Could I be personally liable? And like I said, if you're a volunteer, or if you have volunteer board members, if you have a board where people ask this question, you can say, well, do you have insurance? You should have directors and officers insurance for sure. The most important beneficial reason to have that insurance typically is because of attorneys, because lawyers cost money. And I had a great example. I have an attorney who, she is a doctor, and she's not an attorney. She's a doctor on a board. Board does not carry out medical services. They do something else completely. It's just that it's in the medical world, but they don't provide health services. So she was doing surgery. The surgery went badly. Unfortunately, she got sued for medical malpractice. And wouldn't you know it, they sued the whole organization on which she was a board member, because she was a board member. They have something to do with the medical world. It was kind of more research type of stuff. And so there's no way that any of those directors could be held personally liable because it had to do with surgery. They don't do surgery. Nevertheless, they got sued individually, and it took about $15,000 of legal fees, not my office, but somebody else who did litigation in another jurisdiction. It took them $15,000 to just get them out. To say that's crazy. There's no way there could be liability. So that's just a reminder. Make sure you pay your directors and officers insurance. The state not-for-profit laws, jumping up to the top, basically what's a wonderful thing about that is they codify, in other words, they make clear that directors and officers can be indemnified or made whole to the extent that they are held liable or get in trouble, anything that they could be responsible for. The Not-for-Profit Act says that it's a valid use of a nonprofit's resource. And in our form bylaws, we typically have a paraphrase of that law so that directors and officers see that in the bylaws and they get some comfort. But there's only so much comfort, especially depending on how much is in the coffers of your organization. The best comfort really comes from insurance. There are volunteer protection acts. There's a federal one. There's state laws all over the place, and they really codify the Good Samaritan rule, which is if you're nice enough to help as a volunteer, you should not be liable unless there's intentional misconduct. So if you go to some trade association event and you punch somebody in the nose, you're going to be liable. That's intentional misconduct. Or if you're grossly negligent, you knew that you shouldn't have a group activity bungee jumping where I'm in charge of giving you all the directions on how to bungee jump. That would be a very bad idea. That would be gross negligence. So volunteer protection acts have some limit, but they are very helpful. I'm going to give an example in a little bit that will touch on another area. Potential liability, indemnification is really along the lines of bylaws and other provisions. But another area where there could be potential personal liabilities under a statute. In other words, some laws say we don't care what the Volunteer Protection Act say otherwise. So for example, if you are a director or officer who is involved with some sort of a wage violation, I think there's potential personal liability under Illinois law. Under federal law, if you know that your organization is not collecting and remitting payroll taxes, you could be personally liable. And so there's just some pitfalls you need to be aware of. Generally speaking, if you're a volunteer, you shouldn't be liable, except in these excessive cases of intentional misconduct, gross negligence, or if there's a particular law. How do you know? You can check it out, or otherwise, just make sure you're doing things well as far as you can tell. Okay, I'm going to pause here for any questions, and happy to take them. I don't see anything in the chat, but I can look. I think you have to unmute if you want to talk. All right. I will keep going. Just taking a breath. Okay, good. All righty. Okay, so I mentioned the fiduciary duties, and I will go through things. Basically, the buck stops with the board. And so what does that mean? Well, it's important to show up. It's important to read your board packets, your materials. It's important to think about what you delegate. Like, do you have to know all the laws and what you could be liable for? Maybe you should call legal counsel. Do you have to know how to prepare a 990? Of course not. You would hire an accountant for that. The legal standard is basically that you be reasonably informed. So if you show up, that's super helpful. But there's a book, I think, called 90% of Helping is Showing Up. Nice, but you probably need a little bit more. Think about what you want to delegate. If you want to pay somebody a lot of money to be executive director, should you get an executive compensation study? Maybe. I used to say documentation is my middle name, but it is a really good idea to get documentation about such things. A very common example is you have a board full of volunteers, but you want to pay somebody. That person should not vote on their own compensation. That's intuitive. It's also the law. And so you want to document in the board minutes that the person was recused and didn't participate in that decision. We have litigation going on right now with filings this week where there's a fellow who is a founder who wants to cash out gobs of money. He wasn't paid for about 5 or 6 years. And now he thinks he wants to siphon off all the money. Well, at a key meeting where his compensation was addressed kind of as a catch-up matter, the minutes do not reflect that he was recused, and he prepared the minutes. And he's a very aggressive plaintiff. And so that's one of our arguments was, hey, especially since he prepared the minutes, his name is all over that compensation. It's invalidated because he probably engineered it and he probably voted on it because the board vote was unanimous. So documentation is quite important. Paying attention to the finances, paying attention to workers. Workers are a nonprofit's greatest asset and worst liability because they're going to be your champion. They're going to be your ambassador there. And then they're also going to sue the pants off of you if they feel like they've been hurt and have some sort of a claim. I want to highlight too, there's some Illinois laws that are important. There's the Illinois Charitable Trust Act, which I don't have a slide on, typically applies to charitable funds like held by a 501c3. If you're fundraising for a 501c3, there's some requirements that go along with that. But the corollary is the Trusts and Trustees Act. And basically this law says every trustee, which is everybody basically on a board, so they define that quite expansively, has this duty to invest and manage trust assets. In other words, in layman's terms, if you have about $1 million or more, you should probably be doing something with it besides letting it sit in the bank. And I'm not a financial advisor, but I did just notice I think CDs are going for about 5% annual return. And so why wouldn't you invest in something like that? And if you have more, maybe you should get better advice than from me on how to manage your assets. And the second bullet point shows, yeah, you can delegate and you probably should. So find somebody who can show reasonable care, skill, and caution and how the funds of the organization are managed. If you only have 2 nickels to rub together, then you don't need to worry about it. Hopefully you have more. So what does that mean to delegate within the duty of care? Here's a quote, and this is really important, to act in good faith with the care of an ordinarily prudent person in a like position would exercise under similar circumstances. That's very legalese, but generally speaking, that means that what's objectively reasonable? What would a reasonable person do in similar circumstances if they were you? Would they go get legal counsel? Would they rely on other people? Would they get a committee together to study the issue further? Those are the important aspects of how each director, key employee, officer can fulfill that fiduciary responsibility of acting with care, with diligence, by fulfilling that standard and possibly delegating some information. So here's a few examples. I want to just give this case example. This was very sad from a few years ago. My husband says, "Oh, you have lots of sad stories." I have good stories too. And I'll share some of those too. But this actually happened. Somebody called me and said, "Yikes, our board of directors," there were about 3 or 4 of them, very small board, they all got notices that their personal bank accounts were about to get levied. That's a little love note from the IRS, a notice of intent to levy. So their personal bank accounts were going to be taken to fulfill a payroll tax liability. And what happened was the executive director had not provided financials for 2 years. So you talk about a sleepy board. Apparently the executive director just kept saying, "Oh, don't worry about it. They're coming. Everything will be great. It's all good." So the directors didn't insist on the financials. They didn't really pay attention. They liked the executive director. Unfortunately, not only did the executive director not remit payroll taxes, and this is money that belongs to employees. So the IRS gets really upset about that because it's employees' tax on their wages and it has to go to the government. I assume that some, maybe all of you are aware of that. It's very, very important. And so the way the IRS got their attention was to issue this notice of intent. And then the other sad part of the story was the executive director was having a lot of mental problems. And so as soon as this blew up, she literally checked herself into a mental institution. And the way I got involved was the assistant called and was just very, very concerned. All the directors wanted to immediately jump ship, get off of the board. I said, "Don't you dare do that, because you can be held personally liable for this. This looks like gross negligence on your part." I think one of them knew that it wasn't getting remitted. I can't remember all the details, but whatever board member knew of it certainly would be liable under the statute. And then the others could be liable under that common law standard of gross negligence because they didn't ask for financials they weren't checking up. So stay with us is what I said, and they did. The assistant ended up being the executive director. We ended up working out a payment plan that all worked out. No director lost any money personally, but it was a giant wake-up call. They righted the ship, and they went on. Okay, so also with this duty of care, there's some other areas. Duty of care is very long. I'll just give a little plug now for our website. Wagenmakerlaw.com has a variety of blog articles. One is on the duty of care. You can just type in duty of care. There's also ones on other fiduciary duties, so you can type in fiduciary, but there's a laundry list in that article that talks about all these different things about making sure you have good corporate documents, you're supervising your programs, do you have those financials, are you managing your investments, how are your employees doing, is there anything that would be affected by a whistleblower issue. Here's a few more examples I want to share from recent situations with clients. One was an organization that didn't follow its bylaws, didn't know how many directors they're supposed to have, how they're nominated and approved. There's a variety of other things that were problematic. And what's can be challenging is that the bylaws, there's 2 ways to define the bylaws. One is that written document that you follow. The other is what you actually do. So if you say, "Oh, well, that's kind of a piece of paper, we don't actually do it that way. This is how we get directors on. These are the committees we have." Very typically, the bylaws will say, 3 to 8 directors. Well, we have 12 directors, or maybe 10 to 15 directors, and we actually have 4 directors. So if you're not in compliance with the bylaws, with the written document, does that mean you actually have other bylaws? You have other rules you follow, and in case you have a dispute, are people going to argue about who's on first? very commonly too with members. How are members brought on? What are their qualifications? Are there things that are just outdated from your bylaws, and you need to get those things straight? And so you can have, that's probably we do a little bit of litigation, and almost all of our cases have to deal with board fights. We had a client recently that they wanted to fire their president. Well, the board can fire the president because the bylaws say that the board can fire the president, but it's a membership organization, and the bylaws say the members elect the directors, or members remove the directors. That is Illinois law. If members elect directors, only members can remove them. You can't have it basically in a lopsided way where members elect the directors, but other directors can remove them. Well, that's what this board wanted to do. They've been in litigation about a whole number of things. They're highly contentious people as a culture. I have no idea why, whatever this group is, it's a very dynamic organization, but they have a lot of dispute. And so we've been going for years helping them. So they fired the president. The new president came on, and she didn't know us very well, and that's fine. We tried to get to know her. And so she wrote this, the ousted president sent this thing to us, which we can't talk to her anymore because we represent the organization. It's not her. But she sent this little note saying, I've been told I'm now off the board as a director as well. So I went back to the new president. I said, could you let me know what's going on here? Because I think this is problematic. And then she promptly fired us because I think she didn't want to be told that you can't do that. And so as far as I know, they're continuing to go on with lots of other conflicts. Second example here, this happened just very recently, and it was really sad, but they had an employee who had been actually convicted of child sex offense many years ago, probably almost 20 years ago. And they said, we'd like to hire this person, and the person does a lot of work. We never around children, never ever would there be a problem. And so so they were basically saying, is this okay? Legally, they can hire that person. There's a little bit of a PR issue because somebody found out that they hired this person, and that person has that background, and the constituent is very upset about it. So basically, we're talking on a PR level. But by the end of that conversation, somebody on the phone on that call said, oh, well, by the way, he's made some offensive comments to me of a sexual nature. Oh, wow. Okay, well, now we've changed the dynamic here, because let's say that person goes out as an employee of the organization, you have an event, that person starts harassing other people or starts harassing other employees. What are we going to do? Is the board liable, or is the organization liable? And you've got to be really careful. So those are things where the directors have to pay attention. And I was on the call with members of the board, and I think one of the answers would be you really can't have that employee. Or maybe you can have that person, but they better be siloed, because there's such a thing as negligent retention liability. If you know that somebody's got problems and you don't do something to either clear that situation or stick them in a super siloed position or not have them work for you, there could be liability again for the organization and for the directors who may have exercised something to the level of gross negligence for volunteers. Okay, and I just want to highlight this too, when you're thinking about membership organizations, this may be something that you're aware of or not, but it's got significant implications. Illinois law and other state laws have similar provisions where members have the rights to these books of account and minutes, basically financial records and corporate minutes. So that's a huge reminder to keep your minutes brief. They should not be transcripts. They should not be blow by blow. You may have executive session, you may have all sorts of other things. Typically, what I like to see in minutes are we got together, was a quorum sufficient to take board action, maybe have a little roll call who was on there, and then you might have the president's report or the chair, something like that. The financial report could say, so-and-so, the head of committee, provided a summary of our proposed event or planning for the next event. Discussion ensued, and after some discussion, a motion was made as follows. And that's what you have in your minutes, which is you presented topics, they were discussed, maybe a few highlighted questions, particularly if you want to show how you're exercising the duty of diligence. And questions were asked about the expense, the hotel contract, and invitations to go out or something like that. Something very summary, and then there's a motion. We authorize Joe to sign the hotel contract, provided that it's no more than X dollars or within a range or something like that. Because in particular, if you've got members who can come and check out your minutes, you do not want to have, and then we thought about how we could be liable. Maybe we should call the lawyer, or we didn't really know about these numbers, but that's probably fine. Well, I don't know. Are you sure? So we don't do that. We want to keep these records well. We want to watch out for dissension. And what's interesting on that point is that the member can request these documents, but it has to be for a proper purpose. So when people call me and ask me about such things, I say, well, let's check this. And interestingly enough, too, this statute does not have any real time frame, and it gives the members recourse is to file a lawsuit, which is a little nutty. Who's really going to file a lawsuit about this? So probably you're going to have somebody who's going to make a giant stink about the whole thing, and say, basically it's often a kind of a referendum on leadership. I think I represented a dog club once where they were just going neck and neck in leadership, and somebody was trying to get the treasurer out. They thought the treasurer was a horrible person. Treasurer called me and said, I'm not a horrible person. Member was asking for financial records to kind of make their case. And so we slow boated that a little bit, because the person who was causing the problem was just a real pain in the neck, and everybody pretty much agreed, and they didn't want that person in their dog club, and they were trying to figure out how to get that person out. In the meantime, they're asking for records. So the records were brief. We took our time with that, and we insisted on that person stating in writing what they want and what their purpose is. Because if the purpose is to defame the treasurer, no. If the purpose is to say, well, I don't think the records of the organization are kept well, maybe. So there's lots to consider with that, and just be aware that members have those rights. All right, I'm going to pause here. Again, I see there's a little more chat. Questions if you want to unmute, or otherwise
Yes, Sally.
Yeah,
Sally, we have a question on the chat line. It refers to the dilemma of board members being perhaps aware that an executive director is maybe harshly treating the employees, or employees are not feeling very well. Is there a liability on directors to know about the employees' feelings and interactions with their director?
Right. That's a very common question. I appreciate that being brought up. I've dealt with that a number of times. It goes back to that hourglass. Really, employees are matters for the executive staff to deal with, but sometimes there could be a whistleblower issue. Whistleblower laws are not nearly as broad as people may think. There's a federal whistleblower law that has to do with crimes and violations of federal matters. But there could be other, like sexual harassment, there could be a whistleblower dynamic. And so I would say that generally speaking, if you have an employee who has a concern, they should, and it could be an employee handbook or somewhere else, they should feel empowered and encouraged to come to the board president or some other designated person to address that, and then to assess to what extent is that something that needs to be addressed. I have a client right now, we're about to go through an investigation. Very sadly, I don't know if you ever heard of the story about the man who was going down the highway, and he called his wife and he said, honey, I don't know what is going on, because everybody else is going the wrong way down the highway. Right. So that was this case where this guy he was the executive director, and everybody else had a problem. He didn't have a problem, but everybody else had a problem. Weird, huh? And so they had employees coming, and there's some alcohol abuse issue. There finally was some sexual harassment type, but we now have about 5 different people complaining, and the board finally decided to do something about it. But it was very hard, because the problem person is the founder, who was very trustworthy, or people thought they could trust him. So those are hard situations. Generally speaking, the executive director needs to be respected as that point person managing the staff. And in my little anecdote, it was the executive director, so that was the problem.
Right.
But I want to encourage staff to go, not to the full board, not necessarily expect that the board is going to take up their cause, but the board should be aware of that, and they should treat it very seriously, especially if there's some sort of potential liability, some donor implications of, like this situation. They said this guy would drink a lot and then be very abrasive with the donors. And so, not to be, mercenary about it, but I mean, hey, who wants to lose, your constituencies because somebody's being a jerk?
Sure. Thank you, Sally. A second question resolves on the issue of recording of committee and board meetings, legal
Yeah.
issues.
Yeah. Let me just go back one. I see this. Just one other thought that I've had with it that I've seen. Just reading this question, second guessing how the executive director manages their people. but the fact that the board should know how the staff are feeling and doing, that's kind of problematic, because at least the way the question's phrased, it's a great question, but second guessing, well, that in and of itself is like, wait a minute. But it is a good reason to say, look, executive, and I've done this too, say, executive director, what are you doing about evaluations? Are you evaluating people? How are the evaluations going? I did something when I was on a board, and it was about a 10-person staff. And I said, I'd like permission to just check in with every person on the staff and see how they're doing. But I got the blessing of the executive director, please. But we also, from a management of him perspective, we said, you're not doing the annual evaluations. You need to do that. There's a lot of really good cultural surveys out there. Should you do one of those cultural surveys? So instead of me injecting myself and doing that myself, we're basically, our board was telling the executive director, we want you to be a better manager, and we think you have deficiencies in how you manage. So we're going to school you, we're going to help train you up, hold you accountability as a manager, get some other resources for you. And then there was just that one little touch where I said, could I please go talk to each of the 10 people? And I did, and each of them felt very, very encouraged. And one reason I want to do this, is there anything else in addition to what the executive director might be doing wrongly or rightly? And every single one of them said they loved how the executive director managed them. We got like maybe 2 little tiny things, and that actually directly impacted a very large bonus we gave him that year, because we said, you're doing a great job, you've improved a lot, you've taken to heart this management advice we've given you. So we didn't get in there and micromanage the staff. So how are the staff feeling? And I would want to ask that director, are you checking in on how the staff are feeling or doing? If it seems like there's some red flags, maybe we get somebody in there, but it's super problematic. I'm gonna share one little more war story, because you guys told me I could. I had a really problem situation where it was out of left field. I was surprised I'm gonna get to that recording one, but we had a board where we had an HR person on the board, and that HR person was coaching one of the staff, one of the minions. And then one of those minions, the person she was coaching, ended up being a real problem employee. And then like a month later, the board of the members said, oh, by the way, I've been giving her executive coaching. Like, what are you doing? Why are you coaching this person? You're on the board. You are not. And she hadn't told anybody. So she's undercutting the executive director. Now she's conflicted, but she just, a little grace says she couldn't help herself because she's an HR person. So again, to right size that, she should have been using all those wonderful talents she had to coach up the executive director, not to do this behind the back. And then like, oh my goodness, there's potential liability because this minion employee was doing bad things. Does the organization know that she was doing bad things? Well, I don't know. Do you ascribe what this HR/director, it's just a can of worms. So, know your lanes and try to stick into them. Stay with them. On the recording the board and committee meeting minutes, we have a blog article, and I'm trying to remember what it is. I can provide that later if one of the community people send me a friendly email reminder. I'm happy to send that and some other blog articles. But it was, I think it's called Press Record Recording, and we have that blog article directly came from that very question, which is we want to record board meeting we want to record board meetings, committee meetings. Should we not? Just like as we're on this call, if you get permission, yes. But I think my caution with that is you do not want to have that as a substitute for your minutes. So I would call those notes. I would only have custody with the secretary for the recording, because you're going to get into conflicts and arguments and that kind of thing. If there's a dispute, maybe you share the recording. I've had that where people were disputing it, but the recording is not the minutes. And that's why people review the minutes from the prior meeting, and that's the official record. So you can read that blog article on Press Record. And then if you'd like, you can email me, or somebody from community can email me. And I have a policy that directly provides more detail, and maybe if you want to record for other purposes as well. Great questions.
Thank you.
I'm going to go, sure thing. Okay, so now I'm going to go on here. Okay, and so the second duty is the duty of loyalty. I know David talked about this. I'm going to talk about it from my war story legal perspective. 3 key things here that people ask all the time. Oh, it's a conflict of interest, we can't do it. No. Is it permissible or is it impermissible? Classic example, like I shared earlier, is executive director's compensation. Executive director is also on the board. Well, sure, you can compensate that person, but that person's not going to vote. So it's permissible, provided that these safeguards are followed. And one of them would be then for the independent directors to ask the question, what is in the best interest of the organization? Should you hire me to provide bungee jumping training? Well, one, am I a good person to hire? No, I'm not. Two, is it a good idea to have a bungee jumping event? Probably not. That's why I use it as an example. So is it a good idea to hire somebody as a photographer at the event? Well, what is their rate? Well, do you need a photographer? Why don't you have just some Joe person? Well, that's very, unprofessional photograph. So maybe it's a good idea to hire them. What if the photographer is somebody on the board? How lovely, as long as they're good. What if that photographer is going to offer half price? Well, this is where we go into this documentation, because what is half price? If you had those board minutes later that said, Joe's a photographer, Joe volunteered, Joe didn't vote on it, great. But like, wait a minute, Joe charged $500. Well, how are we, wow, he charged, that's a lot of money. I mean, I could have done it for $100. Why don't we put in the minutes? Joe offered at $500, that's half his normal rate. Susie and Bob did some due diligence. There's no way we could get it any cheaper. He's a really good photographer. It's the best interest of the organization. So let the minutes reflect, or a special resolution reflect, that he was recused and that this is in the best interest, and therefore it's permissible. Sometimes a good example of impermissible can be where maybe somebody's on your board and another board, you have a lot of common opportunities, you're serving similar constituents, and you just keep bumping up against the same issues. And so maybe you need to, and that's really back to my little war story about the board where the Lonely Prophet executive director came on, and this one director said, since I go chase after similar grants, I think I need to get off. And they worked that through to say, no, it's not really a continual conflict. It's at the most, it's going to be episodic. So don't leave. And so the duty of loyalty involves this misuse of position of trust for personal advantage at the organization's expense, most commonly manifested as a conflict of interest. It can be financial, it can be corporate information. And this question can raise, well, how are you involved with other organizations? And so we kind of have talked about that. So I'm going to go on. Every organization represented in our talk today should have a conflict of interest policy, not only because I'm confident of that, because you guys are responsible enough to come to this session, that's part of your duty of care, I think, but also because you're probably filing 990s with the government, and the IRS 990 has a question, do you have a conflict of interest policy? The correct answer is yes, because IRS cares about this a lot. IRS mostly cares about financial relationships, but there could, you could have a special loyalty, like, I was using my example of when I wanted to put a program through on the board I was on. If you like me more than your role, that's not a good idea. So these conflicts can come in all sorts of interesting and insidious ways, and you really want to think about following a written policy where you disclose the conflict. Conflicted person is recused, the board has an evaluation, you document it, you vote on it, and then you monitor maybe how that goes on if there's an ongoing issue. Also want to highlight, you should have annual disclosure statements. The conflict of interest policy should provide for that. So hopefully this is familiar to you. You do that annually, maybe at your annual meeting. If you don't do that, email me or through Community. I'll provide you with a sample annual disclosure statement. And then, midstream during the year, if something comes up, you can always modify that or make sure that the board minutes reflect how those were addressed. So here's a few examples. And I'm just going to run through these kind of in the interest of time here. These are famous, the two first ones are famous cases, at least in Illinois. The Stern case is hilarious because, it said there was fiduciary duties all over the place. One of the directors worked at a bank, and so he volunteered to help manage the funds. He did it. He did a great job. I think he got paid. He also got promotions at his bank. So it wasn't just, the whatever commissions he might have made, but he was really benefiting in his professional career by managing this sizable investment. And some of the directors got very upset about it. And there were different problems. And basically, some of the directors didn't care about it. The directors who did manage the director who managed the asset was clearly conflicted. They didn't follow through with their conflict of interest policy. But what was two key things that resulted from it was, one, the organization was actually better off because he did a good job. And so when the disgruntled directors went to court, the court made a note of saying that yes, this was a bad thing. This director should not have breached his fiduciary duties. So it wasn't really no harm, no foul. But it's a good thing that they did make off better. And then the other kind of the funny thing with this case was that the court ordered that once a year, the board read the judge's decision. In other words, remind ourselves of how we're not going to do things that are the right thing to do. So that was kind of the prescription, the judgment was they had to read this opinion every year. The second one is a great example about opportunity costs and whatnot. So hopefully none of you ever go through this. So this is the duty of loyalty. And there was the board was considering getting some real estate. And it was people were divided, and one director said, no, you don't want that real estate. So they voted no, and sure enough, he went after it, and he bought the real estate himself because he had the inside scoop. So that's one of these conflict of interest involving information. Board of directors, all directors have a duty of confidentiality as part of their duty of loyalty to keep such information private. So in that case, the remedy was that the director had to sell the property to the club on the same terms that he got it. So he basically had to make the board whole for usurping this opportunity. And the last one, I just want to highlight, this is another war story from my coffers about basically there was an organization that wanted to buy some real estate, and the seller didn't like that organization. And so the board chair went and bought the real estate himself, and then turned around and sold it to the organization. And that's very problematic in terms of like, is that the Milo case? And so what happened was that they hired me to develop a very detailed corporate resolution that just basically laid out what they did, why they did it, how it's in the best interest of the organization. That's why I said it was a straw man. The board chair did not vote on that decision to turn around and sell the property. It's fairly unusual, but there was a reported case in Florida similar to that, where the board chair bought the property and sold it at a slight increase and got in trouble for that. And he defended the increased inflation and, cost money to do all this work and whatnot. So you just want to be really careful that what I would think of as a friendly transaction. There was nothing wrong with it from a nonprofit standpoint, but you really need the documentation to show that it's entirely legitimate. If you had to tell it to the judge or jury or to a successor board or the IRS, you want to be able to explain that. And the last duty is really a subset of the duty of loyalty, which is duty of obedience. David talked about that. I tend to define that a little more narrowly, which is to stay true to the mission. And my example about how I wanted to do this new program, we could have changed the mission. But you want to do that carefully and very strategically. And that's why I have that compass, because your compass is pointing the way. This is the quintessential responsibility of the board, is to have those bumper guards, to know the mission, to know it cold. That's actually how David and I met. That's our funny story. We were in the elevator, literally, and we're talking about what we do as professionals. And I say, a lot of times if you were in the elevator talking about your organization, what would you say? How can you make sure you stay true to it? I love this example that if any of you have ever read Matilda or seen the movie, the Roald Dahl movie, there was Miss Honey, who was the sweetest teacher ever. So I had a client that had a Miss Honey, but Miss Honey had a lot of health issues. And this was a school that was connected to a church. And so Miss Honey had a lot of problems. She could barely come to school for a while, and everybody felt bad for her because she was the best teacher ever. And so there was a board meeting of the school, and the school said, well, what's about disability? What about, helping her, can we give her some part-time work? And can we just flat out give her some money because we just feel so bad for her? Can we give her some benevolence? Well, that is not the mission of the organization. A lot of charitable organizations, a lot of religious organizations do have a benevolence component, giving out free soup, helping the homeless. That's wonderful, but that was not the school. The school's mission was to educate children. So do we tell Miss Honey, too bad, tough luck, good luck, hope you get your whatever you need? Well, what they did was, and this is another, there's conflict of interest issues here, but there were some people on that school board who were also involved with the church that was connected to the school. They know each other. This is not a conflict of interest at all. That we vetted that part. But what they said was, the church has a benevolence fund. So why don't we go tell the church about Miss Honey? And sure enough, the church gave some money to Miss Honey to help tide her over. That's within their mission. to help the lost and the lonely and the hurting. And they had a benevolence policy, and they had, you know, you have to have financial need and all that. So oftentimes there are wonderful answers out there, but they're not necessarily, you know, the way that you might think they come out. Or when you think about the boundaries and the guardrails that a board needs to follow, it's wonderful to be innovative and to be visionary. But again, let's be boring and let's hew to our mission in a kind and loving way, hopefully. Just a little word on founder syndrome. I know David talked about that as well. And here's some key elements. You've got somebody domineering, or you've got the martyr. Martyrs are kind of insidious because they're often the kindest people you'll ever meet, but they're like, oh no, that's okay, I'll write up all the minutes. That's okay, I'll do all the other stuff. That's okay, I'll manage all the employees, even though I don't know what I'm doing. That's okay, I'll train for bungee jumping, even though I don't know how to train for that. And you know, you can say, stop, wake up. You need to have a robust board. So the symptoms are often a lackluster board, or somebody who's just doing too much. In this court case we have where they didn't keep the minutes of the guy who voted on his own compensation, probably, he was a founder. He has an enormous entrepreneurial spirit. He's a powerhouse, and he is powering his way through to wreck that organization right now. And they never held him at bay. He had he held the puppet strings over, as far as I can tell, over one board member. And he actually, as far as I know, he lied to the whole organization and said it was going in the tank, so they should all bail out. And then he had kind of his marionette that he could control. So founder syndrome can be very scary. And the cure really is what you're doing right now, which is to think about how to have an engaged and vibrant board, and then to follow up. Think about your strategic planning. Think about your board development. Think about your succession planning. All the things that are going to say, okay, we're not going to ossify and have a few people, whether they're the Mother Teresa of the world or the devil himself, they're not going to be the ones that control that board, because again, you have to have at least 3, and hopefully you have more to have some really good dynamics. Thinking too about connections with other organizations. I touched on this, but I want to do it in a little bit different way. Could be a conflict of interest, could be some other things. A lot of trade associations that I'm aware of have a C3 arm. And so you want to think about that, the C3, to maybe provide scholarships, to do some charitable outreach. Phenomenal, but just remember to stay in those lines, because you don't, if you're going to have a joint event, who pays for what? A little bit beyond the scope of this session here together, but you know, a C3 should not be paying for a C6's activity. A C3 cannot engage in political campaign activity, although a trade association can. C3 might be sponsored by a business, which is lovely, but the purpose of a C3 is not to promote a line of business, which is what a trade association is all about. So we want to be careful. I'm going to pause and to check in with y'all. I have one little more segment to go. I think we have about 15 minutes more. So if there are comments, I don't see any. I'm going to just keep trucking on through and try to provide about 5 to 8
Sally, we
minutes
do
more
have
content.
one question, Sally, that
Super.
relates to should the corporate minutes always reflect if a recusal is being made by a board
Yes.
member for any issue?
Absolutely. I have a standard corporate resolution. And when I say minutes and resolution, what we do is the minutes reflect it, and then you can have a standalone resolution. The minutes would say the board passed the following matters as reflected in the attached resolution. And so maybe that resolution, the standalone, has the recusal, but I think the minutes should say, at this point, Joe recused himself so that the board could vote on the, whatever I said, the flowers or the photography contract. And then my standalone resolution says, whereas the board always wants to operate with the utmost integrity, whereas somebody's on the board and therefore recused himself. So yeah, be abundant in how you record that information.
And then should the recusal be just from the vote, or should that party recuse themselves from the meeting and leave the room?
That's such a super question. It's so timely in this litigation. The policy will say, conflict of interest policy, the standard IRS version and our version, excuse me, and I'm happy to send our version as well. I often will send follow-up materials as people would like. Conflict of interest policy is that the director recuse himself from the deliberation and the vote, and that means get out of the room. So I think recusal is implicit that person leave the room, but if the minutes want to reflect recused himself and left the room, I think that's just fine. But recusal means you don't just say, okay, because I think in my litigation case, he says he didn't vote on it, but he was sitting there staring at everybody. And that's the problem. And a lot of times I'll get clients that say, well, let's work this through, and then we'll call the board to vote. And actually going to veer more conservative, and as a result of this litigation, to say, thank you for teeing up the issue. I would now like to talk to the independent people about the granularity of whatever this is, because you don't want to taint that. I mean, when it comes to directors and officers under IRS penalties, you can be severely penalized. I mean, that's really in the C3, C4 space, actually. So that doesn't apply as much as C6s, but then there's nonprofit principles that are similar. And then there's these breaches of fiduciary duties and blah, blah, blah. So all to say, let's stay above reproach. So let the record reflect that Joe did not participate in the deliberation or the vote and recused himself and left the room.
Thank you.
Yeah, great. Okay, good. Okay. The last section that I want to address is on corporate documents and best practices, and to really think through how you can best reflect good governance in those documents. So one is your corporate purpose, which should be in the articles and the bylaws. It's not at all uncommon to have something in the articles which are different than your bylaws, which are different than what you put on a website. That's not the way to do it, unless it's some sort of an iteration, like a tagline kind of thing. So trade associations advance a line of business. That's why that language is in brackets. And this, if you go now, go check your articles of incorporation and bylaws. Both should have the same purpose, and you should have something very similar in your website. Maybe it's a tagline or whatnot. But you're also thinking about members' common business interests, not for profit. There's wonderful public policy underlying this, basically saying, why don't you focus on improvement with the industry, so therefore you're tax exempt. You cannot advance the interest of your members rather than the industry generally. And the IRS is pretty good at deciding what it wants to come down on. It comes down as a hammer. And so, you want to be very careful about that. They were really picking on social clubs last year. And guess what? 2/3 to 3/4 of their revocations were social clubs. And so I haven't heard much scuttlebutt, particularly with trade associations, but you just want to make sure you always stay focused on your line of business, and you should be golden. Bylaws need to really address members, and this is something we do in our law firm quite a bit. We get really, really in the weeds. This is kind of like back to the music background, which I don't bring up very often, but music, you take things, if you're a musician, you take music apart, you put it back together, you analyze it, and that's what bylaws are like. Or another analogy, sometimes I think of it as little tiny stitches in needlework. And so it can be kind of tedious. And that's why maybe you have a bylaw committee or governance committee. Go talk to your lawyer, go work out. Maybe if it's 3 people or so, 2 to 4, something where it's not your whole board, but you sort through this. If you're updating or getting new bylaws, what does it mean to qualify for a member? Do you have classes? There's, organizational versus individual. What do they vote on? Do they vote on getting directors in? If they do, they got to vote on getting directors out. That's Illinois law, not necessarily other law. State law. How often do you meet? Some of this stuff, I would encourage you to think about bylaws being kind of the skeleton by which the organization as a legal person moves, and then other policy documents addressing such things. So I had some bylaws years ago where they said, and every member has to pay $10. Please don't put your cost in the bylaws, because then you'll be updating it every year. So you can basically say in your bylaws, costs, benefits, and such other matters shall be addressed in a separate document. But the bylaws do want to address, at least at this minimal level, of how often do you meet. Most critical, what does it mean to be a member? Who allows the members in and out? Typically, it's the directors. And then what do they get? What do the members get to vote on? So then you get the board. And what does the board do? How many people? We've talked about this. Is anybody ex officio, which means by virtue of their office? So if you hire an executive director, that executive director is a voting or non-voting director of the board. That means who's ever in that seat gets to be on the board. That can be good, that can be bad. Do you have terms? I like having our standard language is 2 3-year terms, and then you have to rotate off. So in other words, you can be on the board for 6 years before you have to rotate off for a year. Well, lots of people do it differently. And that's basically back to that founder syndrome, to keep you from ossifying. And then majority vote. That's the most important part of the bylaws. I always tell people is that one little sentence that says, the organization operates through its board by majority vote unless otherwise indicated. In other words, buck stops with the board. The board is the one that votes, and some things are super majority, like amending your bylaws or merging maybe, or voting to dissolve. What does it take to have a quorum? It could be 50%, could be something else. We talked about removal. How do you take board action? You can take board action through a meeting with whatever the quorum is, by a majority vote of the quorum there, or it can be by unanimous written consent, which means you send something around and everybody has to vote on it. Every single person. You don't do hybrid, where some people come to the meeting and some people vote by email or text even. You can have a hybrid board meeting in terms of technology, but when you take board action, it's either the meeting or unanimous written consent. You can have committees, which either are going to have corporate authority like your XCOM, or most other committees without corporate authority. They're more advisory in nature. Who are your officers? We talked about that. What about indemnification? What about really major things like merger amendment or dissolution? And we typically have some financial policies as well. Let's see here. We've talked about some of this with conflict of interest and disclosure statement. I encourage people to have a dispute resolution policy, and it should apply to members. So if you got a beef, let's talk about it together. Basically for two reasons: one, to avoid expensive litigation, and the other is to encourage a robust dialogue, because you do want people to really to engage, feel like they're vested together. Talked about in context of financial policies, and this is an illustration of how those fiduciary duties, everything really comes from them. So should you have an investment policy? If you've got a lot of money, should you have a spending policy? Like, do we only spend the interest income? Do we get to go into the corpus? How much of the corpus do we go into? A lot of organizations don't need these things, but you want to think about that. Encourage you to think about record retention, data privacy, especially this world, whatever you've got online, much more. Do you have a recording policy for your board meetings or otherwise? Lots of things to think about. So I will pause there for questions, and just to spur you on, just to think about what key takeaways you may have from this presentation. Think about what your role is to advance the mission, maybe some key challenges, and if you have questions, I'm happy to address them, follow-up emails, and hopefully you are better equipped and educated to fulfill your leadership role and to help others to fulfill their roles. And thank you again for allowing me to speak with you all. I will stop now and take any questions for 4
Sally,
minutes.
we have a question regarding
Sure.
either a director or a staff person directly standing in the way of the membership application of someone they do not like or have a disagreement with,
Yeah.
even though the
What a
person
great
was
question.
qualifies as a member.
Right. This is my favorite audience, is people who are in the trenches having real life questions. So thank you. Yes. I would say practically, yes, you can, but should you? You may versus can. I don't think they should. I think the best answer to that is to have a membership policy. And so I breezed through that in the bylaws. My point from the bylaws discussion was you need to address membership in the bylaws. You should also have a document that says, well, what needs to be in the application? You have a membership committee. Back to that, committees with corporate or without corporate authority. So if you said the membership committee has corporate authority limited to the following: to allowing people in or out of the organization. So a director could not actively stand in the way of that membership application. If you had a membership committee, that director is not on the membership committee has authority. But what if your bylaws said, the membership committee shall recommend to the board who shall be on, and then if a director actively stood in the membership of an application, the board votes on membership applications, the person completely qualifies in every respect under the bylaws and any other policy, well, then I think that the director, that would be inappropriate, and the director should be outvoted by the other members. And then, back to that robust and conflict resolution, I would say the director needs to yield to the unity of the board and shut up, or address that through a dispute resolution to say, I've got a real beef with that person, or otherwise bring it up to the board and say, kind of like that example I use, like, this person, molested children 10 years ago, it would hurt our reputation. Well, let's talk about that. Or this person is super divisive. And then you need to modify, what does it mean to be a director? Now that we've thought about it, these kinds of people shouldn't be qualified, but just most specific, like that's a micromanagement kind of thing. And the director has an objection. The director should figure out how do they express that best by, revising the membership application, getting other people to vote against that person, figuring out if there's a whistleblower or some other kind of a grievance issue. So there's a real, a lot of times people who have got a beef, they've got a legitimate beef, but they can come off as kind of, offensive in other ways. And so they still need to be taken very seriously, and it needs to be addressed, but with a proper process.
Thank you.
Mhm.
And I see no other questions in the chat room.
Okay.
Well, Sally,
go back to
I will say that that may be the most information in one webinar in the history of it. So that was awesome.
Great.
We will provide a copy of that for everyone to have access to. And as I've mentioned at the beginning, something to share with your boards. And any follow-up questions, as Sally had mentioned, reach out to Sally or reach out to one of our team members. I think, is there any other housekeeping things we want to do before we wrap up?
And before you get to that, then, Sally, because you very kindly offered to send additional information to us as well,
Mhm.
it's probably best that just one person reaches out to you for that rather than us all individually doing that. I mean, you know, you talked about having the blog, about recording notes, recording
Yes.
board meetings, things like that.
Right.
So it's just to be sure that one of us is following up rather than the entire team. There's 2 or 3 things in particular that you mentioned.
Right.
you-
Yeah, absolutely. Thank you. Yeah, I will do that. I have a note on the recording the board minutes meeting with the policy, duty of care. I'll do duty of loyalty, duty of obedience. I have like my little trifecta, and then conflicts of interest. And if anything else bubbles up among you all, then I will look for this one email, and then I'll respond with blog articles and send in some kind of things that aren't on our website about policies that could be helpful.
You can send that. I don't know, was it Shelby? Who was first initially contacting you or liaising with you for today? Who was your liaison?
Sure.
Was it Shelby?
Shelby. Yeah.
Yeah. So I think maybe if you send it back via Shelby, that would be super then. And we can
Okay.
all have access to it. That was so invaluable.
Okay. I will plan on that, and pending any other questions. Oh, and I've got a nice blog article on trade association, so that should be good too. All right. Well, thanks.
Good deal. And thanks. One more thank you to my team, especially my marketing team, for getting out, and Shelby and Megan and Katie and everyone else. Elmer doing some great questions. Caitlin for running the end of the meeting, and everyone else. If I didn't say anything, I appreciate you guys very much, and I appreciate all our clients who are on the call. And I hope everyone has a wonderful. Was it Wednesday afternoon at this point? I think it's Wednesday afternoon. So have a great Wednesday afternoon, and thank you very much.